We love Nashville. And I love Smyrna too, by the way. I just wanted to throw that in there. Our next session deals with intellectual property, which is super important. You'll note, as Brian said, we're going to walk you through from idea, concept, right through to trying to raise some money and selling your product or services, which we all want to do. So the next session deals with intellectual property, and our moderator is a member of Bone McAllister Norton, and is a specialist in trademark prosecution while also working in enforcement and litigation. Paul has practiced trademark law for almost 25 years, so you're going to learn a lot from this. He's going to come on up, Paul Cruz, and a panel of intellectual property experts.
Good morning, everyone. It's great to be here. Great to see everyone out this early and excited to talk about intellectual property. Usually when we're together doing this sort of thing, it's with a bunch of lawyers in the room and they don't really want to be there, but you all clearly want to be here, and I'm glad to see that. Real quickly, you've heard I'm a trademark attorney. My name is Paul Cruz. That's what I've done forever, and I'd like each of the panelists to introduce themselves. Jacob?
Sure. Whoa, loud and bright. Good morning. My name is Tycho Stykov. I'm the managing director of the Propellery, which is a global international advisory law firm, advisory firm that is not a law firm, that deals with intellectual property. So we deal with strategy, we deal with commercialization, exits, placement in large corporations, and so forth. And we also own a company out in Silicon Valley called Venture Growth that is a SaaS product that actually connects intellectual property assets and other innovation assets to corporate M&A transactions.
Cool. My name is Andy Pitchford. I'm an attorney with Waller, Lansden, Dorch & Davis here in town. I do patent acquisitions and sales and services. I acquire patents on software, mechanical, electromechanical, whatever kind of devices that is, and then sell them, enforce them, whatever needs to be done with that.
I'm Matt Schneller. I'm a trademark attorney by trade, although most of my time these days is spent as a startup. I own TMTKO, a trademark clearance and trademark analytics company that just got off the ground and sold our first subscriptions 2 weeks ago. So in your shoes too.
My name is Sam Miller. I'm a shareholder at Baker Donaldson, Bierman, Caldwell & Berkowitz. I've been lead counsel in over 100 IP litigation cases, from patent cases in Silicon Valley to Texas to New York. And at the end of the day, your IP is about enforcement in a way. And so I'm very happy to be here.
Great. Thank you very much, fellas. Before we dive into the topic, I did want to give a shout out to Brian and his team. I think it's fantastic what they've done. This is a very exciting moment to be at the inaugural IdeaCon, and it's really great, guys. I appreciate it. With that, we talked before we came out a little bit about a general question. I think I'll throw it to everyone. We can kind of take it in turn. Would be, why is protection necessary? It might be obvious, but why is intellectual property protection important early in the development of an idea? Whoever wants to.
Well, and being the non-lawyer here, my response was, well, I don't know if protection is necessary. But what I think is necessary is a strategy that may include protection, may include some other topics around it. Sometimes you may not want to file a patent or a trademark because you may want to get a bigger market share. You may want to expand the market. You may want to, if you're in the shared economy, do some sort of a strategic move. You don't know. What is important is to think about it, is to have a plan, and also to really connect that plan to the end in mind. Here's what I mean by that. If you're going to be creating a product, let's say it's a software product, and no one likes to talk about software patents, but these guys have a lot of fun dealing with that these days. But let's say it's a software product, but let's say you don't want to really build a company that you run for the next 30 years. You want to sell it out. Well, think about who you want to sell it out to. And then if you want to file a patent, why not find a law firm that represents that big company? Because if you want to sell that patent, wouldn't it be easy to say, well, there's a little bit of credibility because that lawyer also works on all your patents. That's strategy. It's important to have that.
It is.
So as the patent attorney, a couple of caveats there. If we represent that big company that you want to sell to, we cannot represent you guys in that sale. There's a conflict there.
Right.
So,
You can still do the patent.
yeah, we can do the patent, but when it comes to negotiations, and we can even make introductions, but when it comes to any kind of
And there it
negotiation,
goes.
yeah. So when it comes to any kind of negotiations or like that, we can't do that. If you want to talk about software patents, block off a couple of days, we can talk about
No
that.
doubt, no doubt.
But that's kind of what I do a lot of. I started out doing all that for Microsoft for about 7 or 8 years back in St. Louis, and so pretty well versed in that. The important thing about all this, though, is, especially with patents, doing the international stuff, if you make a public disclosure before you file a patent application, just, we'll tell you what kind, but if you make a disclosure before you file that, you lose all your rights all around the world, except for the US, Canada, Japan has a 6-month grace period. I think Australia may have been looking at implementing one. We have to go look it up because everybody can change that. But you lose your rights if you disclose before you file. So to Staco's point, get a plan before you start doing stuff. It's okay to not file a patent. You may not want to. You may decide, like Tesla, I think, has a bunch of patents that they gave up because they wanted other people to help them build the infrastructure to run their cars across the country. That's a strategic decision to, give up some patent rights. But you have to make that decision before it just gets made because you made a disclosure or something like that. So make those decisions and proceed forward.
So I'm probably the one person on the panel that doesn't have a lot of experience with patent other than as a consumer have filed a software patent application for whatever that's going to end up being worth. We don't know, our lawyers don't know, nobody knows. Fortunately, the softer side of IP protection is much more friendly from the perspective of the legal system. Copyright protection, if you've written software code, if you created something new and creative, you automatically have protection for that. In the US, you may have to register it to get certain rights and to be able to go to court to enforce them. But the US is an outlier. Around the world, your copyright protection is there from the moment you create something new and interesting. Trademark protection, at least in the US and most English-speaking countries, you get some protection just from being out there in the marketplace, which is a big deal. It can be geographically limited to where your customers are, so you get some benefits from making a decision early. Where your customer is going to be, how are you going to reach them? Are you going to have vendors? Are you going to have manufacturers? And making sure you have trademark protection in just those markets as they become important to your company to get ahead of the game. Especially in other countries, first to file is the company that has the rights, and you'd much rather have your trademark rights in China if you're having your manufacturer. You don't want your manufacturer to run out and get rights there and have that to hang over your head once the deal blows up down the line. But fortunately, life is much simpler in the trademark and copyright realm than for patent.
I want to add on. Hello? Okay, add on to that real quick. It's not as important from a statutory time period standpoint, but you don't want to get behind the 8 ball like Matt was just saying. If the other person files first, you're starting from a hole, even though you're the one that came up with the trademark or the idea or whatever.
I've always thought it's the old adage of an ounce of prevention worth
yeah.
a pound of cure. And this is what we're talking about, is that little bit of prevention early can avoid so many issues downstream.
It's cheaper.
It's much cheaper to protect early. Sam?
I was going to say a lot of what Brian talks about is ideation, and what we're really talking about at a very simple level is what is it that is unique about your business that someone wants to steal, right? If you don't have something that someone else wants to steal, there's no value in it, right? So what is that idea, and then building a strategy early on matters a lot, whether it's patent or whether it is not actual protection, but the perceived threat of protection, as in I have something here, I have a patent pending, I have a trademark, a little TM next to it. What is it that I'm doing at the outset that I can keep my lights on, but I'm still doing the amount of protection that I can that'll ultimately give me value in the end?
And I want to add to this. Mm-hmm. Is this working? Good. And intellectual property, it is patents, it is trademarks, copyrights, it is trade secrets as well. It's also the contracts you have with your software developers. That's intellectual property too. The contracts you have with your consultants or employees. That's intellectual property too. It's anything, pretty much anything that's intangible. And This is a wide-known study. 80% of the values of companies today is in intangible assets. It's
I
important
think
to have
that's a
strategy.
very good point, especially when you look at what you find with startups is a lot of oversharing, right? We want to tell everyone about our idea. We want to get money. We want to get market out there. We want to tell our customers everything, right? A little bit of keeping things to yourself. Keep those cards to yourself, which seems very non-creative, very anti-Silicon Valley. I get it. But I guarantee you that no one in this room or outside this room, outside of Google, knows Google's core algorithms to their search engine. So keeping those things confidential is important.
I think that is a very good point, Sam, is that you, surely there are ways to share at a high 40,000 foot level, whatever it is you're engaged in, but not give away the details. Keep the secret sauce secret. But again, and also because it goes back to protecting and preventing something from down the road to be a problem.
To add on to what Stako said about when you're dealing with developers, any kind of suppliers and that kind of stuff, for patents and copyrights, the people who came up with the idea or the code are the ones that own that, unless your agreements have an assignment obligation or an automatic assignment preferably. You don't own that. It may be your stuff, but somebody else owns pieces of it, unless those contracts have assignments in them. That's very important to watch out for.
Yeah, make sure that everybody you work with understands that as well.
And yourself, frankly. A lot of times you start working on an idea before you have a business entity set up, before anything else is in place to have a structure. There's nobody to assign that right to. So you have to keep that in mind once you've decided this is going to be a go, that you're going to move forward with making this a business instead of an idea. Well, you got to get all those rights transferred over. It's not complicated paperwork, but if you don't do it, it can really mess things up.
Well, we kind of, in a way, I think, segged into what was going to be my next question, and I'll pose it, but maybe we've answered it, is what would be the one thing we would want everybody in the audience to come away with if they had just one thing? And mind you, there are many, but if there was one important thing we could convey to them to keep in mind about this journey they're on as they go from ideation to wherever it takes them from a protection point of view. Does everybody agree? It's, I guess, protect it early. Any other thoughts come to mind?
Let's start back.
Yeah, we can start with Sam.
Think of your end game, right? A lot of people, when they start out, it's how do I get the lights on, right? Well, that's a checkers move. You need to be thinking chess-wise, right? What are my next 3 steps that I'm going to do? Because when I get to the end of this journey, or when I get to, let's all hope for the exit, right? When I get to the exit, someone's going to look back and say, what are all the things you did or did not do when they do that due diligence? And that's what's going to determine whether the price that was offered to you remains the price that you sign on the contract.
Maybe this is not a technical point, but as a business perspective, you can get away with different levels of disclosures to different types of people that you're talking to. If you're talking with someone who is in the same industry, who could replicate what you're doing, you have to be very careful. If you're talking with someone who is interested in your product but is not an expert, but is not a trusting customer or business partner, it's okay to disclose a little bit more, assuming you're not shooting yourself in the foot from the patent perspective, because that is not someone who can replicate what you're doing. But there's a high barrier to entry. We sell to lawyers. Lawyers, as you may have guessed, are not trusting people. We have to tell them more about what we're doing, or they're never going to use it. So you can be strategic about how you disclose and what type of information you pass around to your customers.
So I'll go ahead and add on to that is use confidentiality agreements when you're getting started. Until you have at least a provisional patent application on file, just use confidentiality agreements. You can get ones that'll work fine off the web or whatever, and that protects your patent rights. And it's that simple. It's one-page documents that people routinely sign, generally speaking. And that protects your patent rights.
If they aren't willing to sign, probably best not to be
And
working with them
here's the
anyway.
caveat, except for your attorneys, because you
Well,
have attorney-client privilege.
Yeah.
They don't have to have non-disclosure
true.
agreements.
That's
So if you're
true.
talking to an attorney for purposes of seeking representation, you don't have to worry about that.
Right.
So.
Well, I agree with Sam and everybody, but Sam really hit it on have the end in mind. I think that's critical for the path that you're going to take on. Because honestly, if you have the end in mind, a lot of the questions along the way are gonna have answers already. They're just gonna set itself straight. But I think, and I do a lot of advising over the Entrepreneur Center, and I always tell the founders, running a business, starting a business, having an idea, trying to figure out what to do with an idea, it's a very busy, time-consuming thing, and you kind of feel like you're always kind of catching up somehow, right? And it's so important and so critical to pause. And I suggest if there's minors, don't listen to me, but get a bottle of wine, get your best friend, and talk about the bigger vision. IP is part of that. Team is part of that. Advisors is part of that. Who your lawyer is going to be is part of that. What's your end goal going to look like is part of that. Think about that, because it's a lot easier and a lot less expensive to figure out on the front end than trying to fix it later on.
That's for sure. That's for sure. And in listening to this, the great comments each of you have, thinking about your relationship with particularly attorneys. You know, we're all very busy people. We're all, you know, we know what we know. And it's great, though, and very refreshing. I know when I have a client who has done what you all have recommended, which is have an idea of where it is they want to go, rather than walk in with, well, I want to do something, I don't know what. And that can lead to a great frustration, frankly, I think, for both attorney and client, because most attorneys I know, all of y'all included, of course, we want to sincerely help our clients, but we need them to have some vision and some idea and some direction. They are the boss, after all. Our job, of course, is to help them fill in the gaps of their knowledge, because they can't know what we know. But it's important for, I think, all of y'all, when you do approach and work with an attorney, have done the exercise that Stoico just mentioned. Have a fairly articulated plan of what it is you're trying to do. That way you will get a much better outcome, I think, and a better service level from your attorney.
I think that's right. I think a lot of people make a mistake and they walk into the attorney with the office, I'm ready to go. Right? You wouldn't build a house or go to a contractor and say, I don't know if I want 5 bathrooms or 3, build me this, right? And that's what you're doing. So the legal model in our world is changing, and that we have people now coming to us and saying, what is it you want to do? And I fill out, for me, I start at the very front, what is your end objection? How many bathrooms do you want? You know, do you want high polished sinks? We can do that. But we try to get that objective up front.
To that end, usually one of the first questions I'll ask a new potential client after I say, okay, what are we talking about here? Is it a hat? Is it a car? I mean, what are we talking about? Is what's your end game? Do you want to license this? Are you building a company? Where are we going with this? Because that'll determine what I do too, whether it's file a provisional, file a non-provisional, file international applications. What I recommend is going to depend on what you tell me, who your market is, where you're going to go, whether it's just US or you're including Europe, Canada, elsewhere. Where you want to go and what you want to do is going to drive what I recommend as a strategy for patents and other intellectual property assets.
I would tell you, too, if nothing else, all those good things is that it makes it more efficient and less expensive. Because you can spend do a real legal spend spinning wheels with an attorney. Well, we've got about 5 minutes left, and I always like ending this sort of thing with a little bit of, questions. I mean, this is a very creative crowd. I am sure there are some questions at the top of the mind. You, sir?
Earlier you were talking about disclosure. Is that a product market? Is my product out to market? Have I disclosed already?
Sure.
Yes.
Okay. And when I'm filling out copyright and trademark apps, am I putting my personal name or the business name on the application itself?
That's a great question, right? So when you bootstrap, you want to save every dollar possible, right? LegalZoom, I can't believe I'm saying this, LegalZoom has made it very, very easy to open up an LLC to protect yourself, right? There should be very little that is filed in your name, and most certainly, if you have a partner in the venture, nothing should be filed in your partner's name, right? Because there's no better path to divorce, business divorce, than to have someone else own all the assets for your idea and you're left with nothing. All right, so those kind of things should be held in the corporation. As a practical matter, when you go to exit, all of that's going to be assigned over, and when you have a nice, neat package to hand to those sophisticated investors, that's what they want to see.
Is it better to have the business name owning the trademark versus the personal owning?
Yes.
The one thing about LegalZoom will be if there's more than one person involved in the business entity, that is a not a good plan. You definitely want to get somebody to write that up properly, because the LegalZoom stuff can cause issues, especially at exit, in my experience.
For example, LegalZoom, if you go look at who registered their trademark, they paid a big firm to register their trademark. They didn't use LegalZoom to register their trademark.
Right. That's good.
But a point to this, it also depends, and this might be, you just might be starting a business, so a lot of these things may be mute or not, but it also depends, it might be not good to put it into the LLC where the product is. There might be a better strategy to have it in a, excuse me, in a subsidiary that just holds the IP assets. As a matter of fact, if you see most corporations, that's what they do.
Delaware
Which,
Holding Company or
yeah,
something
which,
like
which
that.
allows you to actually create multiple revenue sources around the same asset. And also allows you for different exit opportunities or different licensing agreements. Apologies. Depending on the sorry. Brian knows I'm recovering from a little. I have young kids, what can I say? But it might make sense for that holding company to be registered in a different domicile, depending on where the products may be shipped. If you think about it, I'll give you, obviously, maybe Microsoft, but I don't think you're Microsoft. But if you're Microsoft, Microsoft's IP is all held up in Ireland. And there's a lot of tax issues, and there's a lot of licensing issues as well to help with that, right? So depending on what you're building, how you're building it, again, back to the plan and back to thinking, where am I going with this? So how can I set it up right so I have a good foundation to build on?
There's never going to be, I don't believe, a precise right or wrong arithmetic-like answer. 2 + 2 is 4. Fine, we all agree. Is it right for you or your company or someone else to hold title to your trademark? It's always going to vary depending on the facts involved and the where your goals are.
It also illustrates a little bit difference between the second machine age that Brian was talking about and us. There's still a need for lawyers, unfortunately. And so we
can't
can
get
help
rid
you
of
with
us
this.
yet.
You can't machine all of this.
Right.
I'm trying, but not there yet.
Any other question?
I wanted to ask again about disclosure. What's the minimal hurdle on that? In other words, if I have a product, and I make a prototype and I show it to a couple of customers, have I lost rights? Have I just lost it if I made a presentation and delivered it? Have I lost it if I've shown someone engineering plans? Where do I lose my patentability?
Well, let's think in terms of 1 year, right?
Hello?
So for patent purposes, disclosure, an offer for sale or sale, you have a 1-year window to file that patent application. I think I'd kick it to Andy to talk a little bit about provisional patents is a good way to protect that. When it comes to trade secrets, that disclosure is an absolute bar, all right? So if I have an idea that has economic value that's not generally known by people, type of thing that's difficult to reverse engineer, that I might want to get a longer eternity level protection versus 20 years of a patent, I need to have those confidentiality agreements up front with my suppliers, my manufacturers, with the people you're giving presentations to. And you'll get, and I think Douglas can talk to that, you'll get pushback from Silicon Valley for those kind of NDAs, right? There's a kind of a thought, if you need an NDA, then I don't need to see it.
Well, that's all the time we have. This has been great. Thanks a lot, y'all.